Dear viewers, it's my pleasure to bring to light and focus on a particular point today that is very warning issue for the law and advocates for the country and the world. More particularly, the legal research and study. Before we attempt for drafting any petition, what we need to do is to emphasize more priority on legal research. And without having the legal research, certainly we will not be able to present or will not be able to bring to light a very good drafting. A very good drafting is the layout and the portrait of being success in the legal profession. More particularly, the judges and the honorable court will be pleased enough if you can place a very very accurate and very up-to-date having adequate information of your submission, the drafting. It is well settled and admitted that in different countries of the world, learned advocates are paying more attention, and then they are just trying to become much more apt and skilled with the intake knowledge of drafting. Drafting is the key and most important subject matter of an advocate. If learned advocate cannot present a very good drafting, then ultimately there would be a negative impression here at the time of hearing the matter before the court. So that is why giving priority and putting emphasis on drafting and legislative drafting is another thing though, but legal drafting is fairly needed for us. And to become expert and to become a very good drafter, what we need to do is to read, is to stick to gun with the drafting, the better and the best drafting of the learned advocates, those who are qualified enough and those who are very apt in that matter. Apart from that, legal research. Legal research is the part and parcel of our practice. Without having a good and excellent legal research, ultimately there is a drawback, there is a sign or the dictation that you are not being able to win your case, to make out your case, to make out your submission, to be a very, very good pleader in Bangladesh and in the world. What a learned advocate should have to do is to put and cut your labor time only for the interest of becoming a very good legal researcher. By dint of legal research, learned advocates can search and can find out the exact law point and the logic and the argument for winning and making out the case before the court. It is well settled and admitted more or less by all the learned advocates that without having legal research, they will not be able to make out their case while they will be at the trials. So, and moreover, verbal submission. Learned advocates must have to know how they will submit before the court. They must have to know the pulse of the court. They must have to know the approach, mood of the court, and the way the learned judges or the honorable judges want to deal with the matter. They have to acquire the clear and transparent knowledge about this matter. If it is, then it will be very much easier to understand by the learned advocate how to convince and how to make the learned court or the honorable court pleased enough on the particular subject matter or the brief. So this has to be taken into consideration by the learned advocate also. So not only this, a very good and interactive communication skill is highly appreciated, and it would be highly appreciated by both the learned courts and the litigant people also. So I would like to address to my learned advocates and the law graduates throughout the world, those who want to become a very good lawyer, they must have to think about the verbal submission, a dramatic submission, a very logical and argumentative and interactive submission is always welcomed by the court. by the honorable court. So why should we just be lag behind of becoming a very good verbal submitter? So while submitting before the court, we must have to stick to gun with the subject matter. We need not to derail our subject matter. It is not our turn. It is not our responsibility and the duty to bring to light and to submit anything before the court without irrelevantly. Irrelevant issues must have to be discarded from our submission at all. So to the point submission is most welcome by the honorable court. We are experienced when we know that very often the honorable court and the learned court give priority to the relevant and to the point submission. It's all. If your submission is opaque and if your submission is not transparent, then the judges may feel boring and they may not have put into and they may not have interest to hear to give more concentration on your subject matter or on the issue or the brief at all. So to the point and logical argument submission style is most important. The language of your submission must have to be much more polished and standard. There should have no regional dialect or the mixed language. For example, Bengali and English should not be mixed. If you speak Bengali, then you should have to continue Bengali. If you speak in English, then you may go for continuing in English. So in High Court Division or the Honorable Supreme Court of Bangladesh or any other higher judiciary, more particularly in this subcontinent, English language is highly appreciated. Though Bengali speaking people are very often used to speaking in Bengali in the court, before the court, so there is no excuse at all. So this is also widely accepted, but those who are interested and enthusiastic to develop themselves and to make them ready with international standard and with international arena, they should have to think about the English language presentation or the submission. That will give them a very good flavor and it will be added a very good tool in their professional excellency and so on. So that is why verbal submission has to be to the point and it has to be well organized, well thought and logical, and argument should be based on your case law or the law point or the merit without having any law point or without having any ground you cannot linger your hearing time. That will make your court bold enough and they would have a negative impression on you and your professional career will just stack down and you will not get the exact flavor of your profession. There is no doubt. So to avoid such kind of situation, what the learned advocate should have to do is to be very straightforward with the legal and logical arguments, with law points and grounds and citations and everything. Apart from that, honesty, integrity, and the trustworthy relationship while conducting the cases before the court is badly needed. So apart from this, to be a very good lawyer, what is given much more priority is the client handling. To be very frank, I can say that learned advocate should have to be very straightforward. They should not play hide and seek with their client. Clients come to you, clients come to us with their having their last resort. They may be the victim of financial loss. They may be the victim of their reputation. They may be the victim of the poverty, and they may be the victim of cruelty or brutality. So whatever the situation, actually the learned advocate must have to take them very cordially, appreciate them cordially, accept them cordially, and advise them as per the law. As per the law, without having considered the situation or the subject matter or the circumstances or the fact of the cases, learned advocates, without thinking deeply and without analyzing the law, should not give any false assurance of giving relief to the clients or the litigant people. Litigant peoples all the time try to get the exact and very short, very genuine relief from the learned advocate. So that is why, to remain unchanged the dignity of this profession, learned advocate must have to be stick to gun with the honesty and with the genuinity. So we should not deal with our client having false assurance. We should not recover, or we should not receive material instruction without performing any legal responsibility or duty on behalf of the client or the litigant people. So what we will receive, we will have to give them back. Otherwise, our financial involvement with that litigant people will be illegal. So that is why it is very, very significant and important for all of us nowadays that learned advocates should have to be refrained from receiving the material instruction from the litigant people or the client when they will be sure and they will be confident enough that yes, they will be able to give the exact and accurate or the update or their desired the relief to their client. Then they can do that. Then they can receive the material instruction from the client. Otherwise, it would be nothing more than that but cheating. So this kind of tendency will destroy and shake our professional dignity and the base in the long run. In the consequence, what would be the consequence? In the mind of the common people or the litigant people, they will think about the learned advocate that yes, learned advocates or the lawyers are not honest and they are dishonest and they just try to make money. They just try to bring the money from the pocket of the litigant people, rather giving the relief or their desired and optimum relief to the clients and so on. So that is why it has to be stopped to remain unchanged our professional dignity. However, I was talking about today the important features of being a learned advocate, being a very, very incompetent, extraordinary lawyer here in Bangladesh and throughout the world. So whatever we have spoken here today is very, very warning and crying need, and we must have to stick together with that kind of philosophy, that kind of activity, and if it is, and if we can do so, then the skyrocketing dignity of the learned advocate will prevail, and we will never be disregarded by anybody else here in Bangladesh and throughout the world. Thank you very much. Thank you all. And dear viewers, you are most welcome and you are invited to stick together with my channel. And thank you very much.